Dedicated detectives who investigate these vicious felonies are members of an elite squad known as the Special Victims Unit. These are their stories.
Oh, yeah. Yeah, we looking into him. Something ain't looking right. We got all this paperwork.
The statement, if you mail the statement, what is that? If it's a fraudulent statement, it is mail fraud. I won't go into the little legal dynamics that occurred in this that I thought that would show that I'm not guilty of the charge, but I'm not an innocent person, so I can't complain on that regard. God is going to do what he's going to do. He's going to discipline.
Yeah.
Now, I'm also, at this moment, I'm also in one of the associate pastors at a church. And so I know better. And God is not going to deal with me the same way he's going to deal with anyone else.
You was a pastor when all of this went down?
The intended loss caused by your scheme was $5,486,388.77. Is that all true? Is that true, Corey? Defendant. Yes, sir.
Oh.
Come on now, dog. Come on, man.
But you out here talking about you planting a church. Timothy 3:2, an overseer then must be above reproach, the husband of one wife, temperate, prudent, respectable, hospitable, able to teach, not addicted to wine or pugnacious, but gentle, peaceable, free from the love of money. So the scriptures say that, and you say this.
No, I'm not leaving YouTube just yet. But what I'm going to do, the decision that I have decided, you know what? Yeah, it's going to happen, and it's going to bother some people. It's going to maybe make some folks happy. Maybe some folks, really don't care. No big deal. Doesn't involve me. But no, didn't get another cat. No, none of those things. It's what I have been. And by the way, you all get to say something about it, whether it sways me or not. Maybe, maybe not. You guys can be persuasive. Maybe you're not. No, I'm not going to Ghana. No, I'm not going to Ghana, even though he would like to get me to go to Ghana. No, none of those things. But it's something that I had hinted at before. And so I think it's just go ahead and let you guys know. And by the way, there is you can just simply look in the poll. I've been deciding, been going back and forth, been praying, should I go ahead and start the process to plant a church?
No, God! No, God, please, no! No! No!
Oh, yeah?
Later this year, I am going to start hosting live, in-person Bible studies. What's going to happen with that is that would be how it's going to start. So now I'm not even sure where. Have no idea what location, what part of town, what have you. But what I'll do is use that kind of as the one, start doing Bible studies in person, but two, there will be some people that will start showing up, and those will be the people that will also help to plan as we start the church. So
come on now, dog. Come on, man.
Word. An overseer then must be above reproach and also free from the love of money.
Restitution keeps on coming up. What is our standard biblically, legally, morally? Thanks, brother. The question was, they say that I lied. Listen to this, ladies and gentlemen. They'll say things like, Corey, you lied. You said that you paid the people back. I've never said that. I've never said that. I've never said that.
What?
I said those people have been paid back. I said those people have been paid back. I said those people have been paid back. I never said I paid him back. I never said I paid him back. I never said I paid him back. The question is, Corey, you stole $2.8 million. Where's the money? You've never paid it back. I said I did. Have you paid the $2.8 million? How are you still qualified to be a pastor? I'll never be your pastor. Kick rocks. I'm lying about what?
Come on now, dog. Come on, man.
I'll never be your pastor. Kick rocks. Word.
Have I personally out of my pocket paid? Nope, can't, never will, never will, never. Have I personally out of my pocket paid? Nope, can't, never will, won't be able to. I think they've been paid.
So restitution, and correct me if I'm wrong, but settling out of court with a bank and restitution, one is civil, the other is criminal. That's what he did, the restitution side.
If he owes restitution, then he owes restitution.
But you want to plant a church. Word.
The bank settle with the victim. That means the bank make the victim whole, but the bank still needs to be made whole.
Mm-hmm. Okay. Yeah. Well, that's why.
But he's making money.
He's definitely making money, though. He's making money off of this.
And that's what you need to let that officer know, because if he's got 152 subscribers, he's making 1,000 subscribers. He's making money off of that.
Yeah, he has two channels. He has two channels and a Patreon channel. But his revenue is at least $9 grand a month.
Oh.
Yes, ma'am. Oh, yes, ma'am. Between $7,000 and $9,000 a month. AdSense revenue.
Yep. Call over to Northern District, tell them that, and if the person you're talking to, do you feel like they just, always move up and have to speak to a supervisor or something?
Okay.
But yeah, if that's what if he's making that kind of money and he owes restitution, then yeah, the government would love to know so they can get their cut.
But the court say you still owe, or you're still paying. There's a reason why. Now, I still pay for a specific reason. I am.
Wait a minute.
But I thought you said.
I said those people have been paid back. I said those people have been paid back. I never said I paid them back. I never said I paid them back. I never said I paid them back. The question is, Corey, you stole $2.8 million. Where's the money? You've never paid it back. I said I did. Have you paid the $2.8 million? How are you still qualified to be a pastor? I'll never be your pastor. Kick rocks. I'm lying about what? Have I personally out of my pocket paid? Nope, can't, never will, never will, never. Have I personally out of my pocket paid? Nope, can't, never will, won't be able to.
Come on now, dog. Come on, man.
But you're trying to plant a church. Word.
I still pay for a specific reason. I am trying to get something else taken care of on my record. Not about having the charge overturned. I'm still trying to get something else taken care of. If a person is in prison and they file to have clemency done, they file to have some sort of clemency, and they simultaneously also have an appeal or a 2255 in the court, they will not answer anything to adjust this record over here for clemency's sake until you take down this other court issue, this other issue you have in the court.
Wait a minute.
So that's why you got two channels and you out here coming at denominations for views to get that money up to get this stuff handled. Word.
Court, such as fighting your case, such as an appeal, or such as a 2255. You have to take that off, let that go, and then file to have an adjustment made to your record or to your case. So why am I still paying anything? And why haven't I not made it applied? Is because I want the court to do something else first. That's all. I want to do that first. Someone says, well, that don't make sense to me. Well, it doesn't have to make sense to you. I'm not asking you to make sense of it. I'm just telling you, this is what's going on. Let me just put this up for you guys to see. This is the case law. You guys can go and check it up. Tarwin can go check it up. I see he's in the comments. He can go check it up. Congress expanded these things to include FedEx, UPS, DHL, because they are instrumentalities of interstate commerce. When the usual business practice included the frequent use of a private couriers, the intrastate courier, other than methods of other methods of correspondence, the inference that the United States mails or interstate carriers were employed is cast into serious doubt. And then the last one, the mail fraud statute does not attempt to criminalize such injurious intrastate use of a private commercial carrier. And so that's the issue. Legally, when I say factually innocent, doesn't mean that I'm innocent, certainly morally innocent, but in terms of if they charge you with murder, you got to meet the statute requirements. If they charge you with this, you got to meet the statute requirement. Well, I didn't. But so wait a second, God, I'm crying out. I didn't meet those statute requirements. Why am I in prison? That's what caused me to focus on me, not to make some excuses, because in prison, you can't make excuses. And is there a difference between me post-prison versus pre-prison? Absolutely. With the business. The business was doing well. At one point in time, it was the second largest black-owned investment firm in Dallas, and growing. We were getting ready to start going to other cities and other states. Well, other things just started happening. The vice president of the company, his wife had some sort of respiratory ailment where they had to leave the state of Texas to Arizona, Nevada, where the air is a little bit easier for her to breathe. The person's over our mortgage department. He leaves and starts another firm. The guy over insurance leaves. The person that's managing the office did not realize how important she was, but she leaves. The operations manager is gone. And so it's like this after this, after this, after this, on top of this sin.
Yeah.
And so things started going down. So what did I do? I took money out of Seiko's account, used it to cover overhead for the business. And when fees or commissions came back in, give it back to Seiko, right? I'm thinking in my mind, no harm, no foul. Anybody that's ever wanted their money, they'll get it back. So, however, you're not supposed to do that.
Okay.
Rounds on that.
Okay.
And in the meantime, even though in between, let's say January and April, I had Seiko's money, but I gave him a statement.
Mm-hmm.
The statement, if you mail the statement, what is that? If it's a fraudulent statement, it is mail fraud. I won't go into the little legal dynamics that occurred in this that I thought that would show that I'm not guilty of the charge, but I'm not an innocent person, so I can't complain on that regard. God is going to do what he's going to do. He's going to discipline.
Yeah.
Now, I'm also, at this moment, I'm also in one of the associate pastors at a church. And so I know better. And God is not going to deal with me the same way he's going to deal with anyone else.
You was a pastor when all of this went down? Word.
Happen. You're not going to sit and play around with me and my name and make me and my name look bad. I'm going to deal with you, but mainly because I love you. I'm going to knock you down and I'm going to build you back up. Because what should have been a 1 year, 2, 3 year sentence at max, I'm told that, Corey, you're looking at 1, 2, maybe 3 years, at the most maybe 4 or 5, but you've got a real good shot of getting probation. Okay, cool. What did the judge tell me? He told me 240 months. That's 20 years, y'all. That ain't 3, 4, 5 years. And
for one time offense?
Yeah, first offense.
And what was the charge? Mail fraud? What was it?
Mail fraud. 1 count of mail fraud. And oh, by the way, I pled guilty. Who gets the maximum sentence? The maximum sentence for the 1 count was 20 years. Who gets a maximum sentence for pleading guilty? You plead guilty because you're making it easy for the prosecution, and so in exchange you get a lighter sentence. That's the whole point of it. I could have went to trial, and at the end of the trial, got up and cussed the judge out and everybody else, and still got no more time than they gave me on a plea. Who gets that? Me.
Wow.
Well, part of it had to do with this attorney that I had. I found out 15 minutes, literally 15 minutes before sentencing, that it was her first federal case. She lied to me. She told me I've been doing this before. Her first federal case. She never asked for the evidence. None of that stuff.
What?
Well, and I won't go into all the particulars.
Yeah. Wow, bro.
There was a so-called friend of mine who he was worried that the government was going to come after him, and he got up and started telling lies that I did this and did that, and so they can throw in these different enhancements. Well, moving past the whole legal issue, one of the people that actually got up and spoke, who came for my as a character witness for me, was a former pastor. The former pastor, after hearing what the government had to say, decided that the best thing, this was his testimony before the judge. Now he's testifying on my behalf for leniency, but he tells the judge, I think the best thing for Corey is for you to give him the maximum sentence the law allows. So
who said that too? Who said that?
I won't say his name.
I mean, another name. Wait, was this
a former pastor? A former pastor.
Wow.
I didn't have time to be angry. I was shocked and disappointed at the moment. Like, what? Oh, what?
Wow, bro.
Now, it takes me a few days for the shock to wear off. 20 years.
This is a sworn affidavit that this is. Oh, by the way, this is Walter Jones' podcast. Okay, an unrepentant lying thief is what he titled it. ? I, Kurt Shetler, being of sound mind, hereby state that I am 21 years of age or older, and am making this statement of my own free will, and that no one has induced me or promised me anything in exchange for making this statement. I swear and affirm the below statement to be true and correct to the best of my understanding. I am the owner of KS Couriers and or about from December 2003 through November 2006, Corey Minor, through his company, Christ Minor Investments.
Come on now, dog. Come on, man.
Christ Minor Investments? Christ. So you had the Lord's name on this. Word.
Utilize our company to deliver statements to his clients on a continual and regular basis. All deliveries were made in the Dallas Metroplex. Notice, all deliveries were made in the Dallas Metroplex, as my company only delivers locally and not out of state. I also testify that I have not been previously contacted by Corey Minor's defense attorney, nor anyone else associated with his criminal case. Let me ask you this question, Jason. Why did Corey feel the need to post this document on Sir Walter Jones' show?
I have no idea.
You have no idea. I figured
you do.
Oh yeah.
What was it?
It's right there in the second paragraph.
Which is what?
I'll play it. Let's see if he says it.
Let's see. So I want you guys to see, because someone says, Corey, hey, he didn't have affidavits to back up his point. Well, let me just make this bigger so you guys can see this. There's just one affidavit from the people that actually delivered for us. This KS Courier Company, they delivered, and he states that they did this and they do not go out of town. So guess what? If I'm delivering, now they're fraudulent statements, without question, then it's not a federal violation. Why is that important? Well, because when I am later on in prison, and it's hard filing cases, it really is. And so I filed something the incorrect way. I could have come back and filed it the correct way, and the court would have accepted it as new evidence received. And then she was, at some point in time, was going to admit to not actually taking the, not actually investigating, but even if she didn't, this, because if you look at the date of that particular affidavit is 6 years, 7 years after the fact. So it qualifies as new evidence. The reason why this is important, guys, the reason why this is important is not me sitting there trying to get by or anything like that, is because in 2018, 19, the court says, nope, you're through. We dismiss this case. I could have filed again. And everyone is saying, Corey, file again. Other attorneys, there are a lot of attorneys in prison. File again. This is how you file it. I'll help you, get you out of here. This is because they cannot meet the standard. So what do? I say, no, I'm not going to do it. I give up. Lord, I'm coming.
Which is a lie. He didn't give up. He kept filing it, and he filed so many times that they warned him that he filed again that they were going to sanction him. But let me go back to this document here, because it shows you clearly why I was mentioning here on the screen here. I am the owner of KS Couriers, right? Look at the date. December of 2003 through November 2006. Corey Minor, through his company, Christ Minor Investments, did utilize our company to deliver statements to his clients on a continual and regular basis. From approximately December of 2004 to July 2005, Corey D. Minor misused customers' funds. In December 2004, Minor deposited customer funds in the amount of $18,800 that were designated for the purchase of corporate bonds into an account that he controlled. Minor then sent, or caused to be sent, the customer's account statements, which showed that the customers owned corporate bonds. However, he never purchased any bonds for the customers. Minor did not refund the customers' money until July 2005, and then only after they demanded the return of their funds, in addition, from approximately February to April 2006. NASD staff requested that Minor provide certain documents in connection with his investigation of his alleged misuse of customer funds.
Come on now, dog. Come on, man.
Christ Minor. Christ. Were
Minor provided some documents. He failed to timely and completely respond by, among other things, failing to provide complete bank records, including bank statements and canceled checks. In late March 2006, Minor provided NASD staff with copies of what he represented to be the previously requested bank statements. However, it was later determined that the statements had been altered and falsified. Minor never provided copies of canceled checks. Sanctions that were ordered, barred. Without admitting or denying the findings, respondent consented to the described sanction and to the entry of findings. Therefore, he is barred from association with any NASD member in any capacity. From or about March 2001, 2006 to on or about March 24th, 2006, the staff of the State Securities Board conducted an inspection of the registered firm's branch office where Corey D. Minor was located and was the branch manager. During the course of the inspection, Corey D. Minor repeatedly denied immediate and complete access to certain books and records related to the business activity of Corey Minor and or the firm, including financial records related to Corey Minor and or the firm's activity at the branch office. Corey Minor provided the staff documents purporting to reflect the account activity in specific bank accounts. The documents did not reflect the true activity in the bank accounts. Corey Minor created and or altered and or caused to be created and or caused to be altered the documents purporting to reflect the account activity in specific bank accounts. In July 7, 2006, the Texas State Securities Board alleged that registered representative refused to furnish documents requested by its staff, and that when the registered rep did furnish the documents were altered. On August 2nd, 2006, the Texas Securities Board entered an order confirming these allegations. Firm received notice of the order on August 4th, 2006. The events leading to these allegations occurred prior to the registered rep's association with its firm. Registered rep repeatedly represented that bank and financial statements were accurate and that he was going to retain counsel and contest the charges. Registered rep subsequently decided to consent to the order of denial. Upon receiving notice of the order and after consulted with the firm's regulatory consultant, the firm determined it was necessary to discharge the registered rep. Former charge and description: fraud. Number one, how many counts? 1. Felony or misdemeanor. Felony. Pled guilty. Sentenced to 20 years in federal prison and ordered to pay approximately $2.8 million to investors as restitution. Beginning on.
Come on now, dog.
Jesus.
Come on, man.
That's why you going so hard on him, my boy. You owe the plug. That boy owe that money.
Or about 2003 and continuing through November 2006, Minor obtained money from customers of various brokerage firms by knowingly and falsely representing to the customers that the money would be used to purchase securities, primarily bonds. Minor, in fact, obtained money from these customers and used it for his personal benefit. He collected over $5 million from at least 64 investors. Now, Corey contests that it was 64, but we'll talk about that in another court document. Minor concealed his activity by issuing falsified account statements to his customers. Texas State Securities Board. Findings of fact. On or about, number 2, on or about April 11, 2006, respondent submitted to an application for registration with the Securities Commissioner as an agent of Emerson Equity, LLC, a registered securities dealer, which is currently pending. During the course of the inspection, The respondent repeatedly denied immediate and complete access to certain books and records related to the business activity of the respondent and or synergy, and consistently avoided providing financial records related to the respondent and or respondent's activity at the synergy branch office. Respondent's consistent avoidance in providing the financial records requested by the staff constitutes a constructive refusal to furnish information requested by the staff. The types of financial records that the respondent constructively refused to furnish included bank statements, a check register, and a ledger in a general ledger. On or about December 8, 2004, 2 Texas investors provided a cashier's check and a check each payable to Christ Minor and each for $9,400. Respondent was an owner and or was an officer and or held bank accounts in the name of several entities, including Christ Minor Inc., Christ Minor Investment LLC, Christ Minor Financial Services LLC, Christ Minor Insurance Services LLC, and Christ Minor Saxony Purging Incorporated, collectively Christ Minor entities. On or about December 10, 2004, the cashier's check and check provided by the investors were deposited in a bank account belonging to Christ Minor Saxony Purging Inc. Respondent and respondent's wife were the only signatories on the account.
Come on now, dog. Come on, man.
Respondent and respondent's wife were the only signatories on the account?
On or about April 3rd, 2006, respondent provided the staff via facsimile a document purporting to reflect the activity in an account belonging to Christ Minor at State Bank and Trust. The check register stated that on December 14, 2004, 2 checks numbered 2014 and 2015 were made to a payee, Lifeline, in the amounts of $9,400 each on behalf of each of the investors. No payments to a payee named Lifeline were made on behalf of the investors on or about December 2004 from an account at State Bank and Trust attributable to any of Christ Minor entities. On or about March 24, 2006, respondent provided the staff documents purporting to reflect the account activity in a specific State Bank and Trust account. The staff had requested the State Bank and Trust statements from the respondent so that the staff could review the account activity in that particular State Bank and Trust account. On or about April 3rd, 2006, respondent provided the staff via fax documents purporting to reflect the account activity in a specific Bank of America account. The staff also had requested the Bank of America statements from a respondent so that the staff could review the account activity in that particular Bank of America account. State Bank and Trust statements did not reflect the true activity in the State Bank and Trust account listed on State Bank and Trust statements. Bank of America statements did not reflect the true activity in the Bank of America account listed on Bank of America statements. Respondent created and or altered and or caused to be created or caused to be altered the State Bank and Trust statements so that the State Bank and Trust statements did not accurately or completely reflect the activity in the State Bank and Trust account listed on the State Bank and Trust statements.
Lord have mercy.
With respect to the creation and or alteration of the State Bank and Trust statements and the Bank of America statements constitutes a fraudulent business practice and pursuant to Section 14.83 of the Texas Securities Act and is a basis for the denial of respondent's application for registration and is an agent with the Securities Commissioner. Order. It is therefore ordered that the application for registration of Corey Dwayne Minor as an agent with the Securities Commissioner is hereby denied. Signed and entered by the Securities Commissioner this 2nd day of August 2006, Denise Voigt Crawford, Securities Commissioner. Corey Dwayne Minor responded and his signatures affixed to the document, and the Director of Inspection, the Compliance Division's signatures affixed to the document as well. Transcript of the plea hearing. Let me cook. All right. Very well, Mr. Minor. Your full name is Corey. No middle name, Minor. Is that correct? Dwayne. All right. Dwayne. All right. Now, have you received a copy of the information that's pending against you in this case? This is the plea transcript. Yes, sir. All right. I want to remind you that any statement that you make Any statement that you make here is under oath. That you are here, that there are, severe penalties for making a false statement, including prosecution for perjury. Now you have the right to plead not guilty. In addition to having already pled or pled not guilty to persist in that plea, you have a right to have a jury trial, the right to be represented by your lawyer at trial in every stage of the proceeding. In that regard, are you satisfied with the legal representation Ms. Buckner has provided for you in this case? Yes, sir. You have the right at trial to confront and cross-examine any adverse witnesses, to be protected from compelled self-incrimination, to testify and present evidence if you so choose, or compel the attendance of witnesses at trial on your behalf. These rights are guaranteed to you under the Constitution. However, if you persist in your plea of guilty, you'll give up those rights. Do you understand that, sir? Yes, sir. You also have a right to have the nature of the charges gone over with you. You're pleading to count one of the information. Is that correct, Mr. Stover? Yes, Your Honor. Count one of the information charges you with a violation of 18 U.S.C. Section 1341, mail fraud. Now, the government would have to prove the elements of the offense charged against you beyond a reasonable doubt. They first of all would have to show that you knowingly created a scheme to defraud, that you acted with a specific intent to commit fraud, that you mailed something or caused another person to mail something or placed something or caused something to be placed with a private or commercial interstate carrier for the purpose of carrying out the scheme. A scheme to defraud includes any scheme to deprive another of money or property or of the intangible right to honor services by means of false or fraudulent pretenses, representations, or promises. A representation may be false when it constitutes a half-truth. Half-truth. I'll continue. A representation may be false when it constitutes a half-truth or effectively conceals a material fact provided it's made with the intent to defraud. What must be proved is that you knowingly devised or intended to devise a scheme to defraud, and that the use of the United States mail or interstate carrier was closely related to that scheme, and that you either mailed something or caused it to be mailed, or placed something or caused it to be placed with an interstate carrier in an attempt to execute or carry out the scheme. The cause to be mailed through an interstate carrier to be used is to do an act with knowledge that the use of the mail or interstate carrier will follow in the ordinary course of business, or where it says it can be reasonably foreseen. Now, do you understand what the elements of the offense are as charged against you, sir? Yes, sir. I'm also required to go over the maximum penalties that you are looking at here. The maximum penalties the court can impose for count one include imprisonment for a period of no more than 20 years, a fine not to exceed $250,000, or twice any monetary gain to the defendant or loss to the victims. A term of supervised release of not more than 3 years, which may be mandatory, a mandatory assessment of $100 payable prior to sentencing. The court can order restitution to the victims or the communities. The court can order cost of incarceration and supervision. Do you understand that the maximum penalty you're looking at for the violation of this particular section is not more than 20 years? Yes, sir. Just reading that. Let's go to line 13. Page 6. Sorry. Line 13. Okay, I just read that. Sorry about that. Page 10, I meant to say. Page 10. And do you understand why you're on supervised release? If you violate any conditions of your release, you can be brought back into court and resentenced to an additional term of years, even though you've already served years in the federal penitentiary. Do you understand that? Yes, sir. All right. Now, I'm also required to go over the factual grounds. Before I do that, Ms. Buckner, do you know of any reason why your client would not be competent to enter this plea of guilty? No, there are none, Your Honor. All right. And do you find his constitutional rights have been observed in these in these proceedings? Yes. All right, Mr. Minor, look at your factual statement, if you will, sir. Is your signature on the last page? Yes, sir. All right. It says that you operate a securities brokerage firm called Christ Minor Investments. That through Christ Minor Investments, you sold securities to the public. You also employed representatives to work at Christ Minor Investments to sell securities to the public. And beginning in or about 2003 through November 2006, here in the Eastern District of elsewhere, you devised a scheme to defraud customers of Christ Minor Investments and obtain their money by false or fraudulent pretenses and representations. That you obtained money from individual customers at Christ Minor Investments by falsely representing to the customer or causing your customers to represent to the customer that the money would be used to purchase a particular security on behalf of the customer when you knew that this representation was false. That you intended to use it for other purposes. In fact, you obtained the money to use it for your own personal benefit. In order to conceal the fact that you had not used the customer's money to purchase securities, you would cause account statements to be sent to customers that you knew falsely reflected the fact that particular securities had, in fact, been purchased on behalf of customers. Your scheme involved at least 64 victims. Don't forget that part, because that's what's being argued, and we'll look at that in the sentencing transcript in just a moment. Hope y'all not tired. If you are, wake up. Wake up. The offense involved violation of federal securities law on or about January 31st of 2006 and executing this scheme and artifice that you knowingly caused. Here it is right here, Jason. Here it is. This is what they got him for. On or about January 31st of 2006 and executing this scheme and artifice that you knowingly caused a false account statement to be sent by the United States mail. Not his little private courier server that he's been using for 3 years to defraud people on the low. He got caught slipping right here. This is the cause right here. You knowingly caused a false account statement to be sent by the United States mail to a Max McGregor on Drexel Street in Frisco. The intended loss caused by your scheme was $5,486,388.77. Is that all true? Is that true, Corey? Defendant. Yes, sir.
Oh, come on now, dog. Come on, man.
But you out here talking about you planting a church.
They know their money was being borrowed to pay somebody else back, of course, without their permission, without their knowledge or consent. And that some victims received their investment money back. But it was originally obtained by fraudulent statements, which would make them fit the definition of a victim for the sentencing guidelines. And we're prepared also to move forward to establish a restitution amount for Mr. Carberry. And I can very briefly have two witnesses to present on the issue of the obstruction that was pointed out in the revised pre-sentence report. The letter sent to victims. I could probably do that with about less than 10 minutes of this testimony. Special instructions regarding the payment of criminal monetary penalties. Any amount that remains unpaid when the defendant's supervision commences is to be paid on a monthly basis at a rate of at least 20% of the defendant's gross income to be changed during supervision, if needed, based on the defendant's changed circumstances pursuant to 18 U.S.C. section 3664K. Additionally, 100% of receipts received from gifts, tax returns, inheritances, bonuses, lawsuit awards, and any other receipt of money to include, but not limited to, gambling proceeds, lottery winnings, and found money must be paid toward the unpaid fine.
That is why you are doing what you're doing. An overseer then must be above reproach and also free from the love of money. But you trying to plant a church or become somebody's pastor. Word. But then you want to get online and do this?
I just want to start off by saying I am sorry. Sorry for a lot of things that I've done, a lot of things that I've said. There are some people that I really do need to apologize to for a lot of different things. For things that I would have thought that maybe you would have thought that were just beyond my control or just really didn't matter. Things that you would have thought that were probably a good thing, but somehow, some way or another, they become a bad thing. What am I apologizing for? And I'm going to have fun with this particular broadcast because I kind of mean what I'm saying and I kind of don't mean what I'm saying. For one, I'm sorry that I went to seminary. I'm sorry that I'm going to seminary. I don't mean to flaunt my seminary in front of you. I don't know what's gotten into me. It's almost as though I'm bragging by telling you that I'm going to seminary. And I shouldn't do that because no godly person ever would go to seminary. None that I know of. No godly person would ever sit and try to learn a little bit more, study a little bit more, ingratiate himself with church history, with the languages, with culture. No one would do that. Why would anyone in their right mind, godly person at least, go to a seminary? I mean, after all, I did miss out on my opportunity with walking with Jesus. Didn't get a chance to walk with Paul. Did not get a chance to see what it was like with Moses. I missed out. I missed out. Now, I'm also sorry for naming the channel Smart Christians Channel. Even though I don't call myself the Smart Christian, although I do call you guys Smart Christians, I do feel bad. I'm sorry for calling the channel Smart Christians Channel. I'm not the Smart Christians. I do want to be smart. I do want to endeavor to study the scriptures and to make sure that I'm approved before the Lord in how I rightly divide the word. That part.
Come on now, dog. Come on, man.
That's impossible without the Holy Ghost. Acts 5:32, and we are his witnesses of these things, and so is also the Holy Ghost, whom God has given to them that obey him. But you want to plant a church and become somebody pastor, when the text clearly says, an overseer then must be above reproach and also free from the love of money. Word. Now it makes sense why you're on YouTube doing everything and saying everything that you're doing and saying. You got some bread to pay back. And you're very prideful and try to be funny. But you want to plant a church and become somebody pastor.
The dedicated detectives who investigate these vicious felonies are members of an elite squad known as the Special Victims Unit. These are their stories.